You're watching the legal breakdown. So, Glenn, the most recent cause for concern in the DOJ's case against Trump regarding his theft of classified documents was Trump's request to Judge Cannon to move that case until after the 2024 election. Jack Smith has now responded to that request. Can you go over what his response said?
Yeah, I would urge everybody to read this court filing. It's 10 pages, double spaced. It's a quick read. It's an easy read. And it makes clear that Jack Smith is not the kind of prosecutor who's going to mince words or pull punches. He seems to understand that justice is a full contact sport. The brevity, the clarity, the persuasiveness of this court filing is really, I'm going to say, inspirational to this old career prosecutor. I'd like to spend the next 10 minutes reading it word for word, but we're not going to do that. What I do want to do is just read a sentence or two of the opening salvo, which really kind of definitively lays to rest Donald Trump's claim that the judge shouldn't set any trial date, push it way off into the future. And the filing from Team Trump actually asked her to set no trial date. Here's how Jack Smith opens. He said, defendants Trump and Nauta claim unequivocally that they cannot receive a fair trial prior to the conclusion of the next presidential election, and they urge the court to not even consider a new trial date until some unspecified later time. There is no basis in law or in fact for proceeding in such an indeterminate and open-ended fashion, and the defendants provide none. In fact, any discussion of setting a trial date must begin with the Speedy Trial Act, the very first sentence of which forecloses the defendant's proposal here, because it says, in any case involving a defendant charged with an offense, the judge shall set the case for trial on a day certain so as to assure a speedy trial. That's the opening salvo. In the first few sentences, Smith definitively knocks down, using the Speedy Trial Act, that is the law that governs when trials must be set and how trials must be set, to basically, convey to the judge, they can't even get the basics right. And then he goes on for the balance of that 10-page filing to basically say, look, these are the 6 things that Team Trump has offered in its determination to push this trial way off into the future. And in just a few short pages, Jack Smith sets up and definitively knocks down each one of those 6 claims. This really is a model of brevity and clarity and persuasion.
Well, so it's clear there that Jack Smith made arguments that were obviously compelling enough to completely undermine the Trump's team's request. But I guess just on its face, if you do have the Speedy Trial Act, if there's no ambiguity that you have to have this trial after X amount of days, how could they even try to justify eliminating a court date and just kind of leaving it open-ended, God knows how many months into the future?
They don't try to justify it. They ignore the language of the rule that squarely applies to this issue, which says the judge shall set a fixed trial date. You know what? Team Trump shouldn't be expected to play by any rules. Donald Trump has never played by any rules. He's never obeyed the law. He's never, paid any attention to procedure, to protocol, to norms, to traditions. So why would we expect him to start now? Of course, the real, $64,000 question is, what will Judge Cannon do with this?
Right. And I guess that leads to my next question, which is, after all of this, is there any reason other than just abject partisan hackery that Judge Cannon would grant Trump's delay?
Here's what I suspect she will do. She will set a trial date because the Speedy Trial Act says she must. What she's going to do is have the parties in at a status hearing next week. She's going to hear from Jack Smith's prosecutors, because he reiterates in this motion that, Judge, everything can and will be done well in advance of the suggested trial date of December 11th, 2023. That's the trial date that Jack Smith, his team, suggested in a previous court filing. He's sticking with it. He said it was realistic when we first proposed it. It remains realistic. She's then going to hear the arguments from Donald Trump's lawyers, and they're going to offer the same sort of nonsense that they put in their last court filing. Donald Trump is too busy running for president. There's still so much discovery that we're waiting to get from the prosecutors. Jack Smith laid that argument to rest. These are such novel issues that we're going to have to litigate them for months and months. Jack Smith said, no, we're not. They're not novel. And frankly, what they're suggesting about the Presidential Records Act even applying, it doesn't, Judge. So let's just keep moving along. She's going to hear from Team Trump. I suspect she'll say, okay, I'll tell you what. I'll give you another month or two. Maybe I won't set the precise trial date that the prosecution has now twice asked me to set, December 11. Maybe I'll give you until January 11 or February 11. I'll give you an extra month or two, but then we are going to trial. That is what a responsible, honest, ethical judge would do, in my opinion and experience. They do like to split the baby, right? They like to appear Solomonic, give the prosecution a little something, give the defense a little something. But, is Judge Cannon going to be an honest broker of the facts and the law? That's still an open question.
Glenn, it's clear that Trump's team is screwing around here, and they're doing it on purpose. At what point can a judge look to, and not that I think Judge Cannon is going to be the judge to do this, but at what point would a normal judge look to impose sanctions on attorneys versus just, giving them carte blanche to pull whatever antics they want to pull in a courtroom? Like, are there instances in which a judge kind of tires of these antics in a courtroom and it can actually impact the attorneys putting forward these antics? Or is it just carte blanche to kind of do whatever you want in the courtroom and it'll either just be swatted down or accepted?
Yeah, great question. Here's what will ordinarily happen. They haven't even conducted the first in-person status hearing with both parties present to begin to make their pitch to the judge about, for example, when the trial date should be set. This has all been done in written pleadings back and forth. So ordinarily, a judge at that first in-person hearing with both parties will set some ground rules and will say, I expect you all to abide by, for example, the schedule I set with respect to filing motions and litigating those motions in advance of trial. And the judge will give them a little bit of rope, and then the judge will wait to see whether the attorneys are playing games or complying, or at least trying to comply in good faith. So judges ordinarily have a little bit of patience. They will indulge a little bit of shenanigans, but most judges, after one or two sort of missteps by an attorney, that's when they will step in and say, if you do it again, I will consider sanctions or holding you in contempt. But ordinarily, they like to establish a track record of attorney misconduct before they bring the hammer down.
Got it. Well, for posterity here, because we've spoken about this in the past, but I think it's still the most important question, so I want to go over it again. If Judge Cannon does grant this delay, we'll obviously see pushback from the DOJ. So what could we expect to see from the DOJ in that scenario?
Yeah, so that's actually a tough question, because when a judge sets a trial date, that's not the kind of issue that a prosecutor can appeal. They can file a motion to reconsider with the judge, making their best arguments for why the judge was wrong in pushing the trial date so far out into the future. But that is really not an appealable issue. So the prosecutors at the end of the day may be stuck with it. Of course, the other thing that they could do is they could reconsider whether Judge Cannon's impartiality can reasonably be questioned based on new rulings, which is the federal legal standard to have a judge removed. The law says if a judge's impartiality can reasonably be questioned, that judge must remove him or herself or be removed. So, but again, I don't expect Jack Smith's team to go there. But here's what it might do. Donald Trump may win a battle, but he may lose the war. It looks like the insurrection investigation is heating up something fierce at this point, with recent reporting about who's being presented to the grand jury in D.C., regarding the January 6th investigation. It may cause Jack Smith to then shift his focus, finish up that investigation, return a federal indictment for the insurrection in the courts of Washington, D.C., and maybe that prosecution begins to eclipse the one that is dragging, courtesy of Judge Cannon in Florida, if that's how Judge Cannon chooses to play it.
And Glenn, do you anticipate that any indictment dropped in the D.C. circuit would basically move faster than that of what's happening in Florida? I mean, don't they call the Florida circuit the rocket docket?
Yeah, but you're only as fast on the rocket docket as your slowest judge. And if Judge Cannon
Look,
proves to be the slowest judge,
looks like we found looks like we found one.
yeah, we found the turtle in the robe.
Yeah.
I don't know if she will prove to be interested in dragging her heels. She might. I have a feeling we're going to know a lot about whether she has learned her lesson from being smacked down previously by the appellate court for abusing her discretion in favor of Donald Trump. We'll see come next week when they have this hearing and she sets a trial date, which I'm quite sure she will, whether she's learned her lesson and whether she wants to try to preserve whatever reputation she has. She's a fairly young federal judge. She's going to be on the bench a long time, life tenure. She may have thought better about putting herself in a position where an appellate court is going to basically make a mockery of her, saying she abused her discretion. So maybe she'll begin to, shape up and fly right.
Well, from your lips to God's ears. Obviously, a lot to stay on top of, both with an impending January 6th federal indictment coming down the pipe, and also, we'll get an answer pretty soon as to what Judge Cannon is going to do in this federal classified documents case. So if you're following along and you want to stay on top of this stuff, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
I'm Glenn Kirshner.
You're watching The Legal Breakdown.